Donald Trump objects to the Court of Appeals expediting his immunity case. We know Jack Smith really wants to get this thing moving. He needs the trial to happen in March. Judge Chutkan stayed a bunch of deadlines, but he is throwing a Hail Mary. If he can get the courts to act quickly, maybe they can get the trial in before the election. So he's racing in Chutkan's courtroom. He's racing at the Court of Appeals. He's waiting for SCOTUS to take the case. But this is where Jack Smith is getting objected to by Donald Trump. And so we're going to see, first of all, Trump's reply to Jack Smith's request to expedite things. Trump says, no, there's no rush. Pump the brakes, buddy boy. And then Jack Smith just issued his reply on top of Trump's response. And so let's get to both of them. Here is what Trump said in the District of Columbia Circuit Court, Court of Appeals, 16-pager. No oral arguments yet. We're just asking about whether this case is going to go fast or not. We know that we're appealed out of Judge Chutkan's courtroom, out of DC. We're asking about the immunity issue and double jeopardy, and things are stayed in her courtroom until this goes forward. And so Jack Smith asked for expedited processing. He's like, can we do this like now, like tomorrow, like Saturday? I'm ready. Trump says, no, we are here in opposition to Jack Smith's motion. Says, all right, listen, Court of Appeals, it's pretty simple. The prosecution has one goal in this case. It's to unlawfully attempt to try to convict and to sentence President Trump before an election in which he is likely to defeat Biden. Now, this represents a blatant attempt to interfere with 2024 and the presidential election and to disenfranchise tens of millions of voters who support Trump. Now, while pursuing a partisan goal, Jack Smith waited over 2 years to bring this lawless case, and then it sought an extraordinarily expedited trial calendar, demanding the jury trial begin in December 2023. He wanted trial like now, like tomorrow, notwithstanding nearly 13 million pages of discovery and a litany of important and unresolved legal issues. And when we were reviewing the discovery case, remember that Walmart versus Visa was like 6 to 7 million. Remember that? Now, in support, Jack Smith made the same argument it makes now. They say that violating Trump's due process rights would somehow vindicate the public interest in a speedy trial. But they were wrong then, and they're wrong now. Now, this appeal does in fact present novel, complex, and sensitive questions of profound influence and importance. Whether a president of the United States may be criminally prosecuted for his official acts as president goes to the core of our system of separated powers and will stand among the most consequential questions that this court ever decides. Now, the manifest public interest lies in the court's careful and deliberate consideration of these momentous issues with the utmost care and diligence. And I love this. I think that they should take time. I don't know why they're rushing things so quickly. You need to go slow, especially when you've got an election coming up. So likewise, the public's interest in ensuring that President Trump, like all citizens, has a full and fair opportunity to develop and to present his arguments to this court. They say a rush schedule, as the prosecution demands, would vitiate these constitutional rights and irreparably undermine public confidence in our judicial system even more than it already has, saying this court should deny Jack Smith's motion to expedite this. Here's why. They say the court rarely grants expedited considerations in the first place. If you want to justify this, you got to have good reasons. The reasons must be strongly compelling. But here, every relevant consideration calls for the opposite, a measured, deliberate approach and not a reckless rush to judgment. Saying Jack Smith cannot and does not and was not able to even argue that there's any irreparable injury here. We can go slow. No reason to go quick. They don't even tell us what standard they'd want to use in the appeal. Instead, they cite the expedited appeal of the gag order, but that includes the First Amendment. And so expedited considerations was warranted in that case because it would be irreparable injury on that one, on the gag order. But there's no similar showing of irreparable injury here. On the contrary, Jack Smith's sole contention that it's urgent is a desire to maintain what they say is an unconstitutional trial date of March 4th. Now, specifically, Jack Smith contends that the public has a strong interest in this case, proceeding timely, and that there's an imperative public interest in timely trials. But Jack Smith doesn't explain why it is, quote, imperative that the trial begin on that date. Why does it need to be March? Why does it need to be 2024? The date of March 4th has no talismanic significance. Aside from the prosecution's unlawful partisan motives, there's no compelling reason why that date needs to be maintained, especially when Trump has other interests and the public has an interest in proper due process of this prosecution. Now, they say that Jack Smith is making arguments. He's citing 2 cases, but those cases don't even involve immunity, so it doesn't change our analysis at all. He says that case was terrible, and this case is a fun case. We have this case, and then we have this case. Now, Strunk did not therefore conclude that all interlocutory appeals in criminal cases must be expedited, and Jack Smith also cited cobbledick and emphasized the importance of prompt resolution in those cases. But cobbledick didn't have any basis here. Cobbledick's not even applicable here, Jack. So especially in other cases, we should go slowly. Expedited consideration would violate President Trump's due process rights. He has the right to investigate this and go slow. Now, from the outset, the prosecution and the district court have repeatedly infringed on Trump's due process rights by denying him time to prepare for this. The initial discovery that they dumped on his back porch was 11.5 million pages of discovery. And it's the equivalent, this is the Washington Monument comment, 11.5 million pages is the Washington Monument stacked on top of itself 8 times. And guess what? You also have 1 million pages to spare on top of that. Isn't that fun? 8 Washington monuments of copy paper, one on top of the other. It's a big building. Now, despite the enormous volume of the discovery, and despite taking nearly 3 years to perform its own investigation before suddenly dropping the charges in 2023, right? So the trial happens in 2024, the prosecution demanded an immediate trial, beginning just 4 months after its initial discovery production. We're going to give you 8 Washington monuments, and we'd like to go to trial tomorrow, please. Thanks. President Trump emphasized that it would be impossible to review such a vast quantity of material in the time demanded by the government. Likewise, President Trump explained inter alia that the unprecedented and complex nature of the charges would present numerous questions of first impression, significant time to brief, there are hundreds of relevant witnesses spread across the country, and so on. But Chutkan didn't care. She says, well, nonetheless, over Trump's strenuous objections, she said, no, you can be ready in March 4th. That's because Molly, highlighter girl, highlighted all the documents, remember? She said, well, it's very organized. They're like, yeah, it's 8 Washington monuments, but it's like got tabs between them. It's like section 1 is the first Washington monument. It has a tab. It says, evidence 1. Just turn the Washington monument over to get to the second section, and then turn it over again to get to the next one. And she said, it's like this, you can read fast, like just read fast, and it's all already organized. So it was insane from a defense attorney perspective why every defense attorney in this country wasn't screaming from the rooftops. I don't know. At least in Washington, D.C., it's insane. But, Chutkan said, I feel good about it. So when they were there, Trump's lawyer said, I feel I need to put that on the record so that there's no doubt that in our judgment, the trial date is inconsistent with Trump's rights. And it's also it's ineffective assistance of counsel. I can't even do my job as a lawyer, obviously. Now, the court did it anyway, said, I don't care. We got to have this trial, acknowledging that the median time from case to commencement in Section 371 cases, nearly all of which are less complicated than this case, is nearly 26 months, right? So they looked up all the other cases out of DC, and they said, how long did those cases take? 26 months. So now we go from August to March is what Chutkan said for a case involving the most extensive, most insane, DOJ investigation in the nation's history, as they always say. Most extensive in our nation's history, democracy. Then Chutkan schedules it from August to March? Come on. Now, in the time since, these due process and Sixth Amendment violations, they've only grown more pronounced. In 12 additional productions, including one just days ago, Jack Smith produced another 1 million pages of documents. We've got 13 million pages now. We also have thousands of hours of audio-visual content. And similarly, back in August, they inaccurately estimated that they would produce 225 or 250 pages total of classified discovery. But no, that's not true. It's been 1,000 pages of classified material. They just keep dumping it out. Now, nonetheless, the district court has repeatedly denied Trump's reasonable requests for extensions of time. She said, no, we're not revisiting the trial date. I don't care if you can't read your materials. But now the prosecution asked this court to compound those due process violations. They want you to expedite this in light of all of that. You want you to go fast so that you, Court of Appeals, can maintain their unconstitutional trial date. So this court should decline to do that. President Trump, like every other defendant, has a right to fully develop and present his arguments on appeal through the regular appellate process, and that right may not be set aside absent compelling justification. Now, a rush proceeding in service of partisan political aims presents no such justification, and the prosecution also ignores that the harm of expedited consideration would have on Trump's First Amendment rights. Right now, they say, listen, Court of Appeals, Trump has a dominating lead for the presidential nomination for the Republicans. He's also the leading opponent of Joe Biden. The March 4th trial date is scheduled for literally the day before Super Tuesday, one of the most critical dates on the Republican calendar. The potential trial is likely to last for months, and it will thus inevitably interfere with American voters hearing from a leading presidential candidate at the height of the campaign in derogation of their First Amendment right to get his speech. Not only Trump's ability to speak, but I want to hear what he's experiencing. I want to hear what he thinks about Areola's GF and what he thinks about deranged thug Jack Smith. I want to hear about it because he is the person who is the victim of the weaponized government. And so who best to advise us about what's happening other than him, which is why they try to gag him. Now, the First Amendment's constitutional guarantee has its fullest and most urgent application when we're talking about political campaigns, and the public interest weighs heavily against expedited consideration here. Say, in the history of the United States Court of Appeals, no president has ever been subject to a criminal prosecution for the exercise of his official responsibilities until now. They started it. Now, the question of whether Trump is immune from prosecution for his official duties is a novel question of law, exceptional sensitivity and importance, one that warrants careful and deliberate treatment, not some hyper-accelerated briefing schedule in a rush to judgment driven by partisan concerns. No, American history abounds with examples of presidents who were accused by their political opponents of so-called criminal activity. Goes back to the dawn of the Republic. Everybody says everybody else is a criminal. We all get it. Could President George Bush face criminal charges for defrauding the United States and for obstructing official proceedings, for allegedly giving Congress false information about weapons of mass destruction in Iraq to drag us into a war? Yeah, he should be charged. If Trump is being charged, go get them all. Could President Obama, for example, could he be charged with murder for allegedly authorizing the drone strike that killed Anwar al-Awlaki and his 16-year-old son, both who were U.S. citizens? Could President Nixon have been prosecuted for obstruction of justice for ordering the dismissal of Archibald Cox on the Saturday Night Massacre? Yes, charge them all. What about John Quincy Adams? Could he have been indicted and imprisoned for the, quote, corrupt bargain of adopting Henry Clay as his Secretary of State? Now, according to President Trump, the answer to these questions is no, obviously. Now, that's an answer that is deeply rooted in the doctrine of separation of powers, but Jack Smith and the prosecution, they disagree. These are questions of historic sensitivity and importance. They warrant the most careful consideration possible, not the breakneck speed demanded by the prosecution. And so, indeed, the prosecution's push for haste has already hampered thoughtful consideration of these issues. Now, in the court below, Jack Smith insisted on a highly expedited resolution of presidential immunity by the trial court, and they obliged. They ruled within 9 days. Now, the result was a hasty consideration by Chutkan of the issues that are overlooked here, and they made a series of fundamental errors. Now, to take just one example, the first argument from Chutkan and her analysis, it contradicts the Supreme Court. Hello. Chutkan reasoned that the absence of an express provision in the Constitution that granted official immunity, she said, well, it's not in the Constitution, so therefore there's no immunity. She said in her order, says there is no presidential immunity clause, she said. Now, the lack of the constitutional text is no accident. Well, that would say then, by this reasoning, it would say that the president has no immunity from civil suit, right, Judge Chutkan? But the Supreme Court has already rejected that in Nixon versus Fitzgerald. They said that the president has absolute immunity from civil suit. How did they find that if there's no clause? They rejected the argument that the absence of the immunity clause implies the absence of presidential immunity. They said no. Instead, that presidential immunity is functionally mandated. It's incident to the office. It's rooted in constitutional tradition and the separation of powers, and it's supported by our history, obviously. But Chutkan doesn't like it. Now, moreover, members of Congress are the only officials whose immunity is expressly spelled out in the Constitution. She said, well, the district court's logic would say that other well-established immunity doctrines for executive officials, like, you know, these people, police, prosecutors, judges, all of whom enjoy immunity that's not expressly provided in the Constitution, she'd throw all that in the garbage too. Now, similar errors of her court's, her opinion, her historical, her structural, and her textual analysis was terrible, as we commented on here. She said, there's no history that supports this. And like the paragraph before that was talking about Alexander Hamilton making that very argument. Now, such errors provide a cautionary note about the importance of careful consideration of these complex and historic issues. Haste makes waste is an old adage, but it's been survived because it works. Now, even if this court grants expedited consideration, don't give them the same schedule that they're asking for. We have a fun quote coming up. It says, even if the court grants consideration, which it should not do not adopt their schedule. They request an opening brief no later than this time. But that is unfair. Jack Smith's proposed schedule would require attorneys and support staff to work round the clock through the holidays, inevitably disrupting family and travel plans. It's as if the special counsel Jack Smith and Molly, they, quote, growled with his Grinch fingers nervously drumming, I must find some way to keep Christmas from coming. coming. But how? From Dr. Seuss, How the Grinch Stole Christmas, Random House, 1957. Yeah, Jack Smith, with his deranged heart, 3 sizes too small. Now, even if the court grants the motion to expedite, which it should not, any such acceleration should be more measured, at minimum 20 days for a scheduling order. And so if you are going to pick up the pace, give us more time than what they're asking for. Now, the court deny the motion to expedite and give us a bunch more time, the 21 days according to the rules that we're entitled to. Signed, your friends, John Sauer, John Lauro, Todd Blanche, attorneys for President Trump. Jack Smith, the Grinch, who stole American justice from the Christmas tree. Typical. And so you see Donald Trump's defense attorneys, another one, very nicely done, submitted this to the Court of Appeals, and we'll wait to see what they say. Obviously, the expedited process here has been adverse and opposed to Trump's due process rights. And so hopefully the Court of Appeals will see it. And if not, well, we'll see what the Supreme Court says about that. So very, very curious. And that is what we've got. Now, Jack Smith also responded to this, and here is what that one looks like. Briefly, from Jack Smith, he's replying in a 10-pager, a little shorter. He says, responding to what we just read, none of Trump's arguments in his opposition has any merit. Rather, consistent with public importance of promptly resolving this case and deep familiarities with these issues, expedited briefing is warranted, since we can type these documents up fast. That approach is consistent, and so grant our request. They say Trump first contends that the case does not satisfy the standard to warrant expedition, but he says the court recently observed that any postponements could frustrate the public issue, and so we've got to move fast. Now, a prior appeal, this is interesting, says here, Trump's suggestion, they say expediting this case furthers the constitutional value, whatever that means, of a prompt resolution of criminal charges, and the need for expedition serves the public interest in a prompt trial that has heightened importance here, not only because of the nature of the issue, but because his appeal suspends trial proceedings, right? So they're admitting, like, we've got to get our trial date back on track. This is not good. Like, it's expediting just to get the trial back on track. But why do you need the trial to be back on track so quickly? What's the rush? What's the urgency? It's obviously political. That was Trump's point in his response. So they say here, it's not accurate that an expedited schedule prevents us from having due consideration. We know these issues. We've already extensively reviewed these things. And Trump has already publicly announced that he's immune. So we've already had status hearings. Trump did not adhere to a schedule. We filed a bunch of briefs here. Government responded. In other words, we can go fast. And so let's just go fast here. Trump also argues that if we expedite it, it's going to violate his constitutional rights. They say that they've got a lot of discovery. But when confronted with those arguments, the district court already dealt with that. All right. So lame. They're just saying, well, Judge Chutkan already dealt with that. You guys are copying, pasting her words. Come on. You got to make a new argument. Nothing about her schedule of the trial date raises a constitutional concern. The fact that there's 13 million pages doesn't matter. She said it was all highlighted, and so who cares? And finally, Trump says if the court grants expedited review, that it would make his brief due the day after Christmas. And they called us a Grinch, Your Honor. But if the court enters this, then his brief would be due on the 23rd, and he could file it early, and so then he could celebrate Christmas with his family. You're very upset about that. I have no one to celebrate with. So in any event, if the court expedites the appeal but provides additional time, please grant this and please schedule it quickly. Signed, James Pierce with Jack Smith's office. Jack Smith, the Grinch who stole justice from America. You see this one here, courtesy of Locals and John McGarvey in the House. Jack Smith, the Grinch who stole due process and justice from America. We're going to save Christmas, my friends, and we're going to save America at the same time. Thank you, John, for the assist. John McGarvey over on Locals. All right, this is the certificate of compliance, and this is what Trump and the government have submitted. Now it is time for us to wait for the United States District of Columbia Circuit Court of Appeals to make a ruling, and we will be here to cover that. As another aside, we're also waiting for the Supreme Court to issue a ruling on this one. They've accepted certiorari on Joseph Fisher versus United States. This was a big one today. The motion to proceed and the petition for a writ are granted. This goes to a major issue about the word corruptly and whether the DOJ charged that. So SCOTUS is taking that. Trump's got some good appeals going, and we see Chutkan lost her jurisdiction over the trial date. So it's a pretty good day for Trump, not such a good day for the government. We'll be here continuing to cover, my friends. Thank you for subscribing to this channel, wherever it is you're watching it. Thank you for signing up for our daily newsletter at robertgovea.com. Also, all the documents that we go through are posted at robertgovea.com in our show reports. So if you'd like to get those documents, head on over there. You can also access the mind map there as well. When you sign up for the newsletter, you should get a fresh link that will take you to the mind maps, and we'll look forward to seeing you here and there on the next one.